Today's decision marks a dark moment in Iowa's history.
And when we got the ruling and saw that, in fact, it had gone our way, it was just pure joy.
Two starkly different reactions to today's ruling by the Iowa Supreme Court that those seeking abortion in the state will soon face strict restrictions by dissolving the injunction put on Iowa law. One from abortion proponents and one from opponents. Those feelings are just part of a spectrum of reactions coming from Iowans today. There is a lot to tackle with this ruling, so I am joined in team coverage tonight with our own Larissa Leone and Connor O'Neill to bring you not only what this ruling means, but how our justices came to this decision. Now, anyone who has followed any happenings on Capitol Hill related to this topic in recent years can tell you it's been a long road. So let's take it from the top. This isn't the first time a law of this caliber was enacted and subsequently challenged. In May of 2018, Governor Kim Reynolds signed the first quote unquote fetal heartbeat law. A lawsuit aiming to strike it down soon followed, and a Polk County judge did just that in January 2019. That litigation took a similar path up to the Supreme Court, after which Reynolds called a special session last summer and the legislature passed her new bill. In the same month, a temporary injunction was granted, which the state attorney general appealed. And that's what brings us to today. The Supreme Court had until today to decide if it wanted to send the lawsuit back to the district courts, make that temporary injunction a permanent one, or, as they ultimately ruled, dissolve the injunction and let the law take effect. But it's not an immediate effect. As you're listening tonight, Iowans can still get an abortion up to 20 weeks in pregnancy. Yet, in due time, that cap will lower to whenever a doctor can detect cardiac activity in the pregnancy. Obstetric experts say this is usually around 6 weeks. And there are exceptions to the rule, including when a doctor deems it a medical emergency to perform an abortion. Tackling the issue of abortion has been a sort of magnum opus for Governor Reynolds in her political career. Today, she said, quote, Iowa voters have spoken clearly through their elected representatives. I'm glad that the Iowa Supreme Court has upheld the will of the people of Iowa. With all this, Iowans still have questions, and that is why Local 5's Connor O'Neill is joining us live from the state Supreme Court. Connor, what are the big changes Iowans need to know about?
Well, Stephanie, after the court issued its decision earlier this morning, we're looking towards a court procedure called precedendo. Essentially, that means about 21 days from today. That means that the state law banning abortions after about 6 weeks of pregnancy will be unpaused.
So it's been a long time coming that we here in Iowa have been waiting for this ruling.
For the sixth time in about 8 years, parties, including Planned Parenthood, argued at the Iowa Supreme Court against the state of Iowa and Governor Reynolds over abortion. And on Friday morning, the court made its 4-3 decision, lifting a temporary injunction placed on the state law by a district judge, banning abortion around 6 weeks of pregnancy when cardiac activity in the gestational sac is detected. In terms of what happens now, parties could appeal the case as it goes back to district court. Precedendo, a court procedure, will most likely take effect in 21 days, letting the district court take over jurisdiction and to vacate the injunction on the state abortion ban law. It's a decision that abortion rights advocates are devastated about.
We know that Iowans will now face unjust and, for some, impossible obstacles in getting abortion care.
In a court ruling, anti-abortion organization Pulse Life Advocates are celebrating.
This ruling reflects the will of the people. And we are a pro-life state, we're a pro-family state, and I think that the people in Iowa want to see life protected, and that's what they're hoping to continue to see as we move forward.
In the court's ruling, it found the state met the rational basis standard to impose abortion restrictions and to protect the life of the unborn. One of the main reasons the court ruled in favor of the state and declaring the temporary pause on the state law to be lifted.
We stand with Iowans and are committed to creating a better future for our state because we reject this new reality.
Now, the Emma Goldman Clinic, an independent abortion provider who you just heard from and also sought legal action against the state, said earlier this afternoon that it anticipates a decrease in the amount of abortion appointments in the next coming weeks. Planned Parenthood also said this afternoon that at its locations in Omaha and in Rochester and Mankato, Minnesota, it anticipates a potential increase in the amount of abortion appointments sought there. Stephanie.
All right, Connor, thank you very much. Now, Larissa, as Connor said, this was not a unanimous decision by the court. In fact, it was just as close to as an even split as they can get. So when we have justices in disagreement like today, what happens?
Well, Stephanie, while Connor has been hard at work to share the next steps in the process, I've reached out to former justices who would speak to the process of a written dissent and how common it is within the Iowa courts. Now, the Chief Justice herself, Susan Christensen, dissented the ruling. We'll take a look at her written words.
While the majority of the Iowa Supreme Court ruled in favor of letting a 2023 law banning most abortions take effect, the court's Chief Justice, Susan Christensen, dissented. Writing in part, quote, "Today our court's majority strips Iowa women of their bodily autonomy by holding that there is no fundamental right to terminate a pregnancy under our state constitution. I cannot stand by this decision. The majority's rigid approach relies heavily on the male-dominated history and traditions of the 1800s, all the while ignoring how far women's rights have come since the Civil War era. It is a bold assumption to think that drafters of our state constitution intended for their interpretation to stand still while we move forward as a society." Michael Streit, a former Iowa Supreme Court justice who was voted off the court in 2010 after they overturned a ban on same-sex marriage in the state, said that dissents aren't commonly published in the Iowa Supreme Court.
I think in the Iowa Supreme Court, dissents are filed probably less than 20% of the cases. So it's not typical, but it does occur from time to time.
The Chief Justice expressing the issue she feels is being misunderstood, writing in part, quote, "It is not whether abortion, with the polarizing reaction it evokes, is a fundamental right, but rather whether individuals have the fundamental right to make medical decisions affecting their health and bodily integrity in partnership with their healthcare provider, free from government interference." Writing, the dissenting opinion was likely done by random selection, meaning it was not Christensen picking this case to write about, something Streit says is standard procedure.
The Chief Justice can't say, well, I'm going to write this one because it's very important to me. That doesn't happen in the state of Iowa. It's assigned by lottery.
Streit believes Christensen's written stance to be a clear reflection of her opinions.
If you read like her dissent today, it's very practical, very just straightforward.
And Stephanie, actually, one of the things Streit said is different now than when he served back in the early 2000s is that all of the oral arguments made in the Iowa Supreme Court and the Court of Appeals are live streamed. So people can observe what's going on in the court, which he believes has increased public engagement with those decisions.
Without a doubt. Good information, Larissa. Thank you very much. Those messages of dissent are shared by state Democrats. Iowa House Democratic leader Jennifer Confirst said, quote, "Iowa Republicans have just gone too far. They are out of touch with the majority of Iowans who want reproductive freedom." Now, we have heard both sides of the aisle weigh in on what they say Iowans want. So what is the truth? While obviously not a scope of all Iowans, a Des Moines Register poll from March of 2023 before the special session shows Iowans do in fact think abortion needs to be legal in one way or another. 61% of respondents said it should be legal in most or all cases. Just 10% polled that abortion should be illegal in all cases.